Negotiating corporate guarantees and indemnities. Hello everyone, my name is Richard Capps, and Redcliffe Training has asked me to say a few short words about the upcoming training course on guarantees, corporate guarantees and indemnities. I want to go straight to talk about the format now that we live in these uncertain times. Redcliffe like now to split their training programs into half-day sessions. So this course will consist of 2 half-days. Session 1 of the 4 sessions will be, well, half of that first session will be talking about the basic background of law. And so I briefly want to mention the circumstances where guarantees and indemnities would not actually be enforceable. Features such as ultra vires, lack of consideration, and so forth. I also want to point out in this early session the difference between a guarantee and an indemnity. And then before the end of the first session, I think we'll get into the guarantee itself. We'll go through a guarantee clause by clause, identifying the importance, particularly from the viewpoint of the beneficiary of the guarantee, as to the importance both of the clause itself and in particular the drafting of the clause, because there are a lot of special words and phrases in guarantees that if you're not careful, if you change them, you can actually alter the legal effect of the document. That will continue through in, as you can see here, in sessions 2 and sessions 3. The last session is letters of comfort, or if you like, letters of support. Many people think that these are not worth the paper they're written on, and that is not entirely true. Some letters of comfort are legally enforceable as contracts, and some are not. And so the purpose of that session is to identify what you have to get into a letter of comfort and the surrounding circumstances of its coming into being for it to be enforceable. And then we will look at some case precedents to cement our understanding of which ones work and which ones do not work from the viewpoint of a lender. Now that's so much for the 4 sessions. I feel that you need additional resources after the course to deepen your research on specific specialized areas. And therefore, you'll see that I'm going to be providing about 16 books. Now, book number 8, which is this one with the red cover, as you can see, is entitled Contractual Indemnities, which is very much focused on our subject matter. The top left-hand corner, loan documentation, chapter 18 is specifically on guarantees. And of course, it covers other loan documentation as well. The other books largely focus on contract law in general. Guarantees and indemnities are, of course, contracts. And some of you may not be familiar with the features that contracts must have. And so lots of reading on that. In addition, I'm giving my own notes on 40-odd pages on guarantees. And it goes into the topic with very substantial granularity. I hope you will agree. And then in addition to those 40 pages of notes, together with the PDF files that support the footnotes to those notes, I always also have here, as you can see, a 1.25 hour video specifically on guarantees and indemnities, so that after the end of the course, I relive the whole process through a video. Okay, well, look, that's a brief summary of what's involved. I very much look forward to seeing you should you choose to join the course. See you soon.